hearing and determine the issue that is glaring in that the defendant has now applied for bail. Now, as I said earlier, bail is an indication of the court taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determine the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June. My lord, this was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access.
Decided to conduct his defense by himself. He has the right to do so. We respect that decision. We wish him well going forward.
Nnamdi Kanu decides to defend himself in court as he sacks all his entire legal team in a dramatic twist in Nigeria's most talked about, trial. Mazi Nnamdi Kanu has sacked his entire legal team and announced he will defend himself in court. This bold move has stirred intense debates. Is it a sign of confidence, frustration, or pure strategy? While some see it as a masterstroke of control and defiance, others warn it could complicate his already delicate case. Whatever the motive, one thing is certain: Kanu has once again shifted the spotlight, forcing both the judiciary and political observers to rethink their positions.
What does it mean when a defendant like Nnamdi Kanu says, I want to defend myself? What are the implications in law?
I don't know any law in Nigeria, so I can't help you, sir. I'm sorry.
You want us to withdraw your law certificates? You're now denying that you have knowledge of law.
Please feel free to withdraw it, because the fact of the matter is that the things that our courts do these days, I was not trained in them, and so I can't help you if it comes to Nigerian law.
All right.
And gladly, I teach international law, which is not made in Nigeria.
But what are the principles of law since your knowledge of law suddenly have just disappeared? Prof, I mean, seriously, what are the implications when a defendant says, I will now represent myself?
In the version of law that I was taught, the relationship between a lawyer and the client is a relationship of agent and principal, with the client being the principal and the lawyer being the agent. And if the principal withdraws the instruction, it is withdrawn, at which point the lawyer is obliged to cease representing the client. Now, in criminal proceedings, what then happens thereafter is between the judge and the accused person, because the person who is client is also accused person, I presume, in a trial. What happens thereafter is between the judge and the accused person. The judge is obliged to allow the accused person some time to reorganize their affairs. And the accused person obviously is entitled, the terms of the constitutional protection, by the way, or guarantee, if I remember correctly, entitle an accused person to represent themselves or through legal representatives of their own choice, as long as subject, of course, to the principle you know very well, which is that the lawyer has to be a person who has a natural right to travel in and out of Nigeria. And so the lawyer would not be a foreigner ordinarily. But other than that, an accused person is entitled to take these decisions. I presume that those are the prerogatives that Mr. Kanu has chosen to exercise.
So, I mean, you look at the trial and the agitation. What are your views about those who are asking? And I'm guessing that those who are asking for the freedom for Nnamdi Kanu are looking at it from the purview of the president granting clemency to about over 170 Nigerians who have been convicted.
First of all, there's a constitutional right to free expression. Advocating for the release of Nnamdi Kanu through the mechanism of peaceful protest, have a constitutional right to do that. I think that, by the way, if I may say so, what the police did 48 hours ago, on the 20th of this month, quite honestly, was terroristic. You cannot, kettle an entire city the way they did, just for the sake of precluding a protest. Now, if they had just marshaled the protesters, along the road, people would have been able to do their business for the day with minimal interference. The idea of imprisoning an entire city just so that you terrorize an entire community sufficiently to preclude a protest is unlawful in my view. It's manifestly terroristic. And it's irresponsible. Now, shooting at people with tear gas canisters and reportedly live bullets, for what? What exactly were those people doing other than freeing Nnamdi Kanu now and raising their fists? I don't understand. And so the deliberate effort by law enforcement to inflame the protesters, in my view, is condemnable.
But the police says that it has a valid court order asking some of the protesters not to go in some, and that's the reason why they said they've arrested Showore earlier today, that the court has ordered that the protesters should limit their protests to certain areas of the city.
If that was what the police were about or were on about, then the charges filed against Aloy Ejimakor and the other people whom they took to the magistrates court in Kuje do not reflect that, because they were charged with conspiracy and a lot of other things. They were not charged with disobeying a court order. All right? Now, and by the way, if the police would not be the people prosecuting for disobeying a court order, that will have to, because that will be contempt of court. That will have to go through the office of the Attorney General of the Federation. So what they're saying is manifestly indefensible. It's manifestly without basis in the facts. Go and look at the charges that they filed. Now, to go then and heist Showore from a court where he had gone to observe proceedings, as every citizen is entitled to do, is just a continuation of this unlawful way of proceeding about policing. And it's difficult. You see, the way they're picking up Showore and aggressing him makes it impossible not to have sympathy for his point of view that the Inspector General of Police is unlawful. You can't continue to aggress a citizen that repeatedly for nothing without in some way making your conduct subject to suspicion.
You were in court today.
Yes,
when Mr. Kanu, for want of a better term, purged his legal team. Mm-hmm. How did it come to that?
Well, he had discussions with the legal team yesterday, and all of us were shocked when we came to court, and the Honorable Attorney General of the Federation previous, Kanu Agabi, announced to the court that himself and the legal team, especially those of the Inner Temple, are withdrawing. And the judge also was shocked and asked Mazi Nnamdi Kanu about it, and he concurred that for now that he would take charge of his defense. Doesn't mean that if tomorrow an opportunity arises that lawyers will not also be part of it. So, but for today, probably tomorrow, he would take charge of his defense. So that's what happened in court. And
were you surprised?
I was pleasantly surprised.
Pleasantly or shocked?
Well, surprised and shocked at the same time. In terms that none of us knew about it. I came to court, just like I've always done, attend the court hearings and all this stuff, and I sat there listening. I kept making any contributions. It's just between Mazi Nnamdi Kanu, the prosecution team and the defense team, and the judge. So as of today, the lawyers have virtually stood down. Whether they have given Mazi Nnamdi Kanu his case files, I do not know. But when you go to section 36(6)(b) of the Constitution of the Federal Republic of Nigeria, which are actually a crucial provision towards fair hearing, specifically to persons who are charged with criminal or capital offenses, is the constitutional right of Mr. Kanu to decide to take over the defense of his own case. It is also his constitutional right that adequate time and facilities be provided for him to ensure that to ensure that he has adequate defense.
Yeah, but I don't think the issue is whether or not I think everybody knows he's got constitutional that right, which is why the judge allowed it. But the question is, what's the thinking behind it? I mean, things aren't going well when you fire the people who are supposed to protect and represent you in a trial, don't you? I mean, did it appear to you to be an act of sort of visceral rage, impulsive, chaotic purge that wasn't well thought out? Or do you think he thought it out?
If you look at the statements made by the leadership, Agabi Kanu, he said after the meeting they had yesterday that the information was told them that they were going to be debriefed and that they respect the rights of Mazi Nnamdi Kanu.
No, I
to debrief them.
understand that, but
So
I'm trying
if
to,
there was
I'm
anything
trying to
that
get to the
happened,
backstory.
no, that's what I'm saying.
You
But
see
if
what I
there
mean?
was anything that happened otherwise at that meeting, I was not in that meeting. I only showed up.
But I mean, you would have heard things. I mean, you talked to him.
No, not
Did
really.
you normally,
we sat-
you
we
guys
sat
normally
closer.
hug each other at,
Yeah,
the,
we
at the
sat
end of the
closer.
trial.
We sat close. We sat
at the end of the day.
At the end of the day,
yeah.
we sat
I mean,
close. But
did he whisper anything into
no.
your
But at the end of the
ear
day, he
or
was actually, he was actually led through the judge's chambers,
Right.
to be evacuated back from the Federal High Court to the detention center. So we didn't have enough time
Right.
to discuss in court. To say, because he's often brought to court 10 minutes to 9,
Right.
and the judge comes out exactly by 9 dot. So there wasn't that much of a time beyond
Right.
the
And
camaraderie.
we didn't hear
the
from, I
visiting.
mean, we obviously saw the statement. I was actually hoping that we would hear that clip from the lawyers,
from the
because they
lawyers.
made a public statement,
yes.
which has been run on a rise
Yes,
sort of
yes,
several times
yes.
today. But I mean, is there anything beyond that public statement that
Nothing-
that might
nothing-
have said perhaps in out of camera to you?
No, nothing yet. I've yet to be informed otherwise.
Right.
But I know that tomorrow he may be meeting with some of the current legal team that were debriefed.
Right.
Maybe possible some additional members of the legal team to go forward, at least to have some people
Right.
who will surround him and be giving him legal advice where necessary, and the authorities that he will need to proceed with the defense of his case. He's already made known to the court, and the court has given summons to 23 witnesses. He will need to spend time to discuss with those witnesses, and where those witnesses are not compliant, to ensure that the court compels them through subpoena to come and testify in court as to their knowledge of events from the time he was arrested to the time he was extraordinarily renditioned, and from the time the trials also began 5-6 years ago. So if you're going to rush, the prosecution has had more than 10 years to prepare for this matter. They've arraigned him on several charges, withdrew several charges, and rearraigned him. They've had adequate time to present their case, and they have rested their case.
Bayo Onanuga, the Special Advisor on Information and Strategy to the President, has called for disciplinary action against Mr. Ejimako for what he called professional misconduct.
What professional misconduct?
Well,
Ejimako is a lawyer by profession.
Right.
He's a Nigerian citizen by profession, entitled to the provisions and to the protection of Section 40 of the Constitution of the Federal Republic of Nigeria, that says that he has a right to peaceful assembly and association. So why is it different? Because he's Ejimako, and then he is no longer entitled to that because he's a lawyer. What about the doctors that came for the protest? What about students that came and many other people that came?
Well, yes,
Are they not
you do have
entitled
a
to the same
point
protection there? So it goes to that pattern, Charles, that I keep saying every single time, that when it comes, especially in the administration of criminal justice, there appear to be two sets of rules in this country, one for the Igbo man and another for every other
Yeah, but of course,
person in
the
Nigeria.
man who organized the protest, Omotosho, has himself been nicked by the police.
Well, I had that today.
Yeah, we saw the video.
I had that today.
We saw it. We
I
saw
had
the
that
arrest,
today.
and it's
Yes, I had that
he's
today.
been arrested.
He's been arrested. But what took them that long? If they were going to arrest everybody, why didn't they arrest everybody all at the same time? Because of the outcry on what may have appeared to be an injustice, particularly on one particular race or one particular tribe, the Igbo tribe, and then maybe just like they said, if you look at what the CP of FCT said. That is almost like an injustice. They have arrested so many others, and then the person who organized the protest was never arrested.
Right.
But even so, has not committed any crime by, protesting under Section 40 of the Constitution.
The reason why Bayo Onanuga was calling for sanctions against a lawyer.
Did they give Tinubu sanction? Did they give Tinubu sanction?
According to them, there was a court order preventing that.
Preventing them from going to the villa.
Preventing parts of that protest from
going to the villa. Where were they arrested? Were they arrested?
But that in violation of that rule, which is why he's saying that there is an issue of profession. I mean, I'm not a spokesman for him. I'm just telling you why he said that and why also Showore has been arrested. But let's move on from that because we're running out of time. I mean, I asked this question of Mr. Showore a few days ago because he was here on the night of those protests. With all the dust that's been raised by the protests and everything else in between, is that likely to make things better or worse for Mr. Kanu?
No, for me, every opportunity to draw the attention of the state to Nnamdi Kanu and the apparent injustice in the prosecution of Nnamdi Kanu. The judge is Yoruba. The prosecution team, all of them are Yoruba. The Attorney General is Yoruba. Mr. President is Yoruba. It appears that, for some elements within the Yoruba, community are looking at this as a new civil war between the Yoruba and the Igbos.
Yeah.
It shouldn't be like that.
Yeah, but you're the one who's saying that.
No, but it's the reality.
No. Well, I mean,
it is the reality, Charles.
It depends on how you interpret.
No, but it is the reality.
Right.
Who is superintending the prosecution of Nnamdi Kanu? Is a Yoruba judge. It's not an Hausa
So
judge.
you're saying that there is.
Who is the prosecutor? Is the Yoruba prosecutor? Who are the prosecution team? Yoruba.
So you're saying that
the Attorney General is Yoruba.
Are you saying there is a conspiracy,
Absolutely.
or there is the perception of a conspiracy? Which one are you talking about?
If you look at the way it is going, and they are resilient and adamant in seeing that Mazen Nnamdi Kanu is not given adequate provisions of time, adequate facilities to ensure that he has adequate provisions for his defense. So if you see how it is going, one may have the perception that is a conspiracy of a few Yoruba people against the Igbos.
Welcome once again to Abel Perspectives, your domain for unfiltered news and raw political analysis. The platform that tells it as it is, not what they want you to hear. Here we go beyond the headlines. We break down the truth behind the politics, the power plays, and the legal intrigues shaping Nigeria today. So before we begin, don't forget to like this video, share, comment, and of course subscribe to this channel so you never miss our fearless breakdowns that bring you the clarity in world of propaganda. Now let's get straight to it, because something big is happening again in the legal and political theater surrounding Mazen Nnamdi Kanu, the detained leader of indigenous people of Biafra, IPOB. In a stunning and unexpected twist at the Federal High Court, Mazen Nnamdi Kanu has decided to, dismiss his entire legal team, choosing to defend himself personally before the court. This bold step instantly set off a political and legal storm. Reactions have actually poured in from every corner, from constitutional lawyers, political analysts, human rights groups, and of course the millions of supporters who continue to see Nnamdi Kanu as a symbol of resistance against what they call a systemic injustice. Now, remember, this is not the first time a political figure in history has chosen to defend himself, but in the Nigerian context, this move is rare, risky, and revolutionary. Remember, some days before this decision, Nnamdi Kanu reportedly, listed a number of high-profile Nigerian figures, actually political figures, including Nyesom Wike, David Nwezumai, Buratai, Babajide Sanwo-Olu, former Attorney General Abubakar Malami, and several others as persons of interest in his defense. Immediately, that list sent shockwaves through the political class. Some say it's a strategic masterstroke, others call it a calculated provocation. But whichever way you see it, Kanu's move has completely shifted the dynamics of his trial. Let's begin with the legal aspects. Under Section 36C of 1999 Constitution of Federal Republic of Nigeria, every accused person has the right to defend himself personally or through a legal practitioner of his choice. This means that Kanu's decision is fully backed by the law. In other words, no matter how controversial it may sound, Nnamdi Kanu is within his constitutional rights to represent himself. During the appearance of legal scholar Prof. Chidi Odinkalo on Channels Television, he was asked about the legality of this move by Kanu. He responded carefully but clearly, saying Kanu has every right to decide whether to sack his lawyers or defend himself in court. Odinkalo went further to emphasize that in legal relationship, the client is the principal, while the lawyers are merely agents. Therefore, as the principal, Kanu has the full authority to dismiss or replace his agents at any time of his choice for any reason, as long as it serves his legal or strategic purpose. On this note, even lead counsel Kanu Agabi, SAN, confirmed this, noting that Kanu has the freedom to choose his legal path and that he and his team wish him well as he proceeds to handle his own defense. From a constitutional standpoint, Kanu has done nothing wrong, but the deeper question remains, is this a wise strategy or a dangerous gamble? Well, the court will decide. From a political viewpoint, this decision might just be one of the smartest moves in Kanu's long and complex struggle. By choosing to defend himself, Kanu could be, reclaiming the narrative, pulling the case out of the usual legal drama that has kept him caged in, technicalities and bureaucracy for years. Several analysts argue that this may be Kanu's way of, bringing the fight back to the political stage where he feels most powerful. He has always been a strong communicator, charismatic, defiant, and articulate. Representing himself could, allow him to speak directly to the court, to his supporters, and to the Nigerian people without the filter of lawyers or media spin. And then, talking about those names he mentioned, Wike, Devumai, Buratai, Sanwo-Olu, Malami, and others, some observers interpret this as a tactical chess move, a way to remind Nigeria and the international community that these are the powerful figures who once had direct or indirect ties to the event or narrative that led to his persecution. Others believe it's a way to expose contradictions, pointing out that during the NSAS panels across Nigeria, Nnamdi Kanu's name was never mentioned in any official report linking him to the mayhem, or should I say the destruction, that followed the protests of NSAS. Yet his name has continuously been dragged into political narratives, especially when violence erupts in Southeast. So the question now is, could this be Kanu's way of flipping the table? Possibly yes. He might be saying, if you believe I was involved in anything, in any sort, in any NSAS protest or whatever, let those who created or spread this claim come and defend them in court. Whereas some think that this could be a shift toward a political solution. Now, there is another layer to this story. Some believe that by defending himself, Kanu may be, signaling a strategy, one that could open the door for a political resolution. Remember, for months, there have been, whispers of negotiations and back-channel talks about a possible political settlement of Kanu's case. So, by taking control of his defense, he might be creating the momentum that forces the government to either rethink its approach or re-engage politically. Because in reality, Kanu's trial has never just been about law. It has always been about politics, identity, and power. So this move could be both a legal assertion and a political statement. Now, let's talk about the elephant in the room, the arrest of Barrister Aloy Ejimakor, Kanu's special counsel. Even though I don't know why mainstream media are not actually talking about this, giving it its traction that it deserves. Professor Chidi Odenkalo called it terroristic, and that word choice wasn't random at all. Why? Because under both Nigerian law and International Human Rights Convention, it is a serious violation to arrest or intimidate a lawyer for representing or speaking up for his client in any manner. Under Section 39 and 40 of the Nigerian Constitution, citizens have the right to freedom of expression and peaceful assembly. More so, the United Nations Basic Principles on Rule of Lawyers, 1990, clearly state that lawyers must be able to perform their professional duties without intimidation, hindrance or harassment or whatever interferences. So, arresting Aloy Ejimakor for protesting his client's prolonged detention is not just unconstitutional, it is a direct assault on the independence of the judiciary. It sends a chilling message to other legal practitioners that defending a real client could, cost your freedom. That in itself a threat to democracy and due process. But remember, the story doesn't end there. Recently, during the peaceful protests calling for Nnamdi Kanu's release, Omotosho, Prince Emmanuel Kanu, Nnamdi Kanu's younger brother, and 13 others were arrested and detained by security operatives. Reports indicate that the protesters were tear-gassed, beaten, and humiliated with live ammunition fired in the air, scenes, reminiscent of dark days of military rule. This once again exposes the troubling, double standard in Nigeria's security architecture. Why is the state so quick to unleash its full military might on unarmed protesters, but reluctant to confront armed bandits and terrorists ravaging the North and Middle Belt? Why is it that the peaceful demand for justice is treated as rebellion, while re-insurgency is handled with negotiations and repentance offers? These are the moral contradictions that continue to erode public trust in Nigeria state. Conclusively, as things stand, Mazi Nnamdi Kanu's decision to defend himself is far more than a courtroom headline. It is a political statement, a strategic test, and perhaps a turning point in a saga that has stretched for years. Whether it becomes his greatest move or his toughest mistake, time will tell. But one thing is very clear. This development has once again placed the Nigerian judiciary, the executive, and the rule of law itself under the global spotlight, because at the heart of this story lies a question bigger than one man's trial. What kind of justice system does Nigeria truly operate? One of law or one of the power? And until the question is answered, cases like Nnamdi Kanu will continue to expose the deep cracks in the walls of Nigeria's democracy. Like somebody said, Nnamdi Kanu's case is likely to be a type that could either mar Nigeria's judicial system or elevate its prudency. You've been watching About Perspectives, your trusted platform for unfiltered news and raw political analysis, the domain that takes it the way it is and not what they want you to hear. If you found this video insightful, don't forget to like, drop your thoughts. Like I do say, democracy is best ascribed, the protest we are talking about is best ascribed by our individual perspectives. So you need to comment, share, and of course subscribe to our channel, because here we don't just report the news, we decode the truth behind it. So thank you so much for watching. Until next time, stay informed, stay conscious, and never stop asking the hard questions.